Hundreds of people charged with sexually abusing children never ended up convicted of a crime against children.
That's what a WIS investigation found after analyzing years of sentencing records in South Carolina.
Our investigative reporter Cynthia Beasley found out about 1 of every 4 cases defendants pleaded guilty to assault and battery instead, meaning they avoided conviction for a sex crime entirely.
Yeah, and offenders can be found guilty and sentenced in several ways. They can plead not guilty and it can go to a trial, or they can plead guilty before then. And sometimes their sentences are up to the judge. Other times charges and sentences are negotiated as a part of a plea agreement between prosecutors and the defendant. That's when those two sides, the prosecution and the defense, agree to a sentence that is given to a judge to sign off on. Now, we often hear from officials when someone is accused and charged of sexually assaulting a child, but we don't always hear what happens next.
They're some of the most disturbing cases in the justice system, and some say they're the hardest to prosecute.
The criminal justice system does not align with the realities of sexual violence.
While some people are charged with sexually abusing a child, that's not always what they're convicted of. So when the case is closed, they may only have a lesser charge, like assault and battery, on their criminal record. I reviewed sentencing records from across South Carolina and found this scenario is more common than many realize. In 2020, a 13-year-old boy told Anderson County investigators a 26-year-old man sodomized him. That man, Donovan Austin Jr., was charged with second-degree criminal sexual conduct with a minor, a felony that carries up to 20 years in prison. Court records show Austin pleaded guilty in 2022, but not to a sex crime. Instead, he pleaded guilty to first-degree assault and battery, and the child sex crime was dismissed. He was sentenced to 10 years, but that sentence was suspended, giving him just probation. So despite a conviction, he was set free. He also wasn't immediately ordered to register as a sex offender. Court records show this was possible because of a sentencing negotiation between the defendant and prosecutors. Out on the streets, not on the sex offender registry, and 7 months after his guilty plea, investigators say he abused a child. Months later, he's charged with 2 counts of criminal sexual conduct with a minor after investigators say he exposed himself and inappropriately touched a 9-year-old. The question is, would children have been safer if Austin was behind bars?
I analyzed more than 2.5 years of sentencing data in South Carolina. Of more than 1,200 cases involving the charge of criminal sexual conduct with a minor, most of the time defendants pleaded guilty to something, but often it wasn't to a sex crime. About a quarter of the time, defendants pleaded guilty to assault and battery. Is that surprising to hear, or is that something that you all see across the country?
I think the rates of dismissal and plea bargaining is not surprising.
Sandy Johnson spent more than 2 decades prosecuting violent crimes in Utah. Now she works with RAIN, the Rape, Abuse, and Incest National Network.
A lot of prosecutors have said child sex crimes are some of the most difficult to prosecute. So they say working out a plea agreement or charging the offender with a lesser crime is the best way to guarantee a conviction. What is your response to that answer?
They are hard cases, and they take a lot of work. It's no longer just calling the child witness and putting the burden on the child. We need to be looking as prosecutors on how we can support the child through the process by looking at the other witnesses that can have information, by using experts that can talk about how children process that information.
Johnson says in cases of sexual assault, the victim usually knows their offender, and the offender could be tied to financial and emotional security, which can lead to delayed reporting to law enforcement.
Juries these days do want to know what they see on TV. They want to see forensics. They want to see DNA. They want to see fingerprints. They want to see video. And sometimes those just don't exist.
Jack Duncan has practiced criminal defense in South Carolina for more than 45 years. He says there are several reasons why a defendant might plead guilty to a lesser crime, including a lack of evidence or issues during the investigation.
There's an old criminal defense term that you're looking for a ham for your client, that you want a really good deal, and that those cases just don't happen.
Every case is different as the justice system works to protect the public as well as survivors of abuse.
An experience of justice for a survivor is such a unique and individual experience.
And Johnson says that's exactly why it's hard to say what the effect is on survivors by just looking at aggregate data. But she says data like this does help them see where there are gaps in the system that could be improved. The sentencing records that we used for this investigation are not readily available online. We had to formally request and pay for them from the South Carolina Judicial Branch, then manually cross-check cases in the public court database. The entire process took more than 6 months. Judy.
Well, Cynthia, thank you so very much. If you would like to see how your local prosecutors are handling these very serious charges, we've shared our full data set and a county by county breakdown at WISTV.com.